How about tomatoes? Does that count? We'll call it roll. John DeWolf.
Here.
Good morning, John. Richard Swezak.
Here.
Rob Lewandowski.
Here.
DeAndrea here. Bob Doan.
Here.
Ryan Thompson.
Here.
Bob Don.
Present.
And the ever-present Al Regina.
Here.
Good morning, Al.
Good morning.
I may jump around a little bit today, but I would like to start with a little bit of background on recent activities and conversations between myself and the Commissioner of DCP, Brian Caparelli. Also in attendance at one of those meetings was John Messner, who's with us today. And John, say hello. And there's been a discussion recently between the department and myself about the way the board reviews applications. And the discussion was that by distributing the applications to all of us randomly, it may be taking more time than necessary. It puts somewhat of an added burden on staff to review the applications, copy them, send them out. So the question is whether or not it's more appropriate or beneficial for the applicants as well as us as members of the board and Jane and her staff and time. So the question is whether or not there should be review of the general applications with a trigger on something that says we don't really have any issues with this particular applicant, and not that they would initially be approved that moment and issued a license, but that the list would come to the board at the next meeting saying these were all reviewed and found to be in compliance with our policy of being consistent with the model law. And initially I questioned the reasoning for that. Why? Are we slowing things down? No. Is it good for us to take a look at them individually, see what applicants are doing, and generally reviewing their qualifications? Or is there any risk in that the staff, not professional engineers or land surveyors, review the applications? So the idea as it was presented was that if any application was found to be inconsistent with the model law as we've described it, or if there's an apparent or possible question about that, and some of that questioning might be relative to the evaluation of a foreign degree or even evaluation of a undergraduate degree. And we have a couple of those today. So my question and concern was, well, how are we going to identify that? And is the staff person going to be able to do that? So I think as it was presented was, if it's obviously consistent with the model law, they're currently licensed and they have the verification without question of the undergraduate degree, then in some way it's perceived that this will expedite. And I responded that, well, quite honestly, we don't consider it, I'm speaking for myself, we don't consider it a burden to review the applications. It is somewhat of a time commitment, yes, but it's what we signed on for. So I'd like to get a consensus of the members here as to whether or not that initially creates any concern or alarm, and just generally have a little discussion about that. As an aside, we recently had our Northeast Zone meeting of the boards, the various jurisdictions in the New England or Northeast section. And in my conversations with a couple of them, it seems that most of the boards have staff review of the applications, and then only the critical ones get sent over to the board for further review. We have several of them today that are in need of discussion. My question is, would they have been identified by staff? I guess that it's not unlike what's being done with all the corporate applications. We never see them anymore, whereas we used to. But staff in the legal department, where it should be reviewed, the staff is doing those reviews, so we never see any of the corporate applications anymore. So, initial reaction, anybody?
Okay, class 4 may be one that we could automate like that. Because those are more straightforward when they have the form from the NCEES.
Right.
Possible, but I don't mind doing it. But I think the class 1 type stuff we should be doing, and especially class 2.
Yes, sir. And I think that was also presented to us by John and Brian, that those initial applications would definitely come to us. The one thing that, John, I would say also is that, while I don't mind doing them also, if they're classified as model law, especially if an applicant has an undergraduate and a master's, and it's not a foreign degree. I think that the evaluation we've found recently can be suspect, in our opinion, by what NCAAS is doing. So perhaps that's an accommodation to us. The initial licenses and the evaluations should come to the board. We can still have a random, but on the other hand, it'll be much fewer, a lot less. I don't think much fewer is a good term, but there'll be fewer applications. And then they could be distributed to each of us so that we really do have time to review and consider. So that might be another way to do it. Yes, Ryan.
Yeah, I think that that makes sense for the class 4s, like you said. But I think that there should be a some sort of spot check, just randomly, and not that I have any concerns with the staff, but I think that it would be in our interest to do some due diligence and say maybe 5% of the class 4 model laws that go through, we take a look at, just basically say, yep, this, we agree. I don't think we should just say every class 4 model law that is a master's degree and non-foreign degree, we don't necessarily look at it. I think that we should have a little bit of supervisory oversight on that.
Right. We had 1 or 2 applications recently where the engineer licensed in another state comes to Connecticut, and he's not really a field engineer. He's a process engineer on a construction site. So, you say, well, his experience may not be what we would like. So that might have been an individual that already went forward and was, because he was listed as model law because of his undergraduate degree. But that's a very rare case, so I'm not real concerned about that. But I agree with you. A random sampling just to keep us up to date would be a good idea. And it's pick a couple. If we're all going to get like 5 or 6 applications every month, then adding in a couple of random ones that are theoretically model law would just keep us current, I guess. So,
Tony, first of all, I'd like to thank you for spending all the extra time doing this for us and spearheading this for us. And you've been doing, I don't know, I've only been on for 27 years, but you've been running the helm and doing it nicely, and appreciate it. And but I don't mind reviewing applications, but if I agree that the class 4 are somewhat automated, if you will, particularly with if they're model law. And if we could be given, with our review, we just give a one-line summary for each one that has been approved administratively. And we can take a quick look at it to see if there's anything that we'd like to look into. Like if it is a foreign degree, or if it's well, they wouldn't be model law, I guess, if it was a tech degree.
Yeah, right. That's another one too. The technology degree, for some reason, there's a reluctance, I guess, to equate a technology, four-year technology degree with an undergraduate degree. And I'll give a statistic on that in a minute. But so we're zeroing in on what we'd like to see. If I'm reading this correctly, some random selection of the typical reciprocity, the first licenses for EIT and EIT and your first license, right, for 2 exams basically, and then the any application that had a foreign degree evaluation. So technology, foreign degree, first license. And what else did I say? I forgot. The foreign degree, any NCES evaluation, first license, first exam. What else?
I think if there's somebody is applying for class 4 and has some criminal proceeding, we should be able to see that one.
Okay.
Because I look at the first page for the NCEES, and if everything is clear on that and it's all model law, then we probably don't need it unless there is an indication that they had some licensing problem or whatever.
Right. That's true. Yeah. And those can be flagged. Jane is able to flag those easily if there was a disciplinary action on another state. So that would be another one, a prior discipline.
They would be non-model law also if they had.
Yeah, right. And that's what, yeah, that flags it. Yes, sir. But that's one we would still want to see. I pointed out a couple of times, I've heard like the guy was fined because he missed his registration by 2 days or a week, you know. Those are extreme. That doesn't really bother me. So yeah, that seems to be a good selection. Rob, you have any comment or thought about that?
I lost you there for a second. No, I agree. I was trying to think about the degrees, the technical degree or non-ABET degree, but if all that wasn't up to snuff, it would be non-model law. So I think
Correct.
I think the
Right.
non-model law is the big net on this thing.
Right. Okay. So, John, do you have anything to add to that, John Mesner, in the way we had our discussion? John,
Give
you're
him a minute
muted right
because he's
now.
going. Yeah, give him a minute because he's going back and forth between 2 meetings.
Oh, okay. All right.
Actually,
Hang
on.
Tony, I have one more comment
Here he
along
is.
the lines of what Bob Doan said is, you know, I know every month with like the class 4s, I put together that chart, right? And
Right.
you plug everything in the chart. I think we all do the same thing. You know, sending that chart around filled out for just a quick once over to make sure, you know, like you said, you could catch that first license might, you know, a New York license or a certain first license might catch people's attention. But if we could pass that around, we probably have to approve it anyway as a board, right? You
Right.
probably have to approve all these anyway, and that's the avenue to approve all of them. You know, that summary sheet.
That's a good question, a good issue, and maybe John, now that he's on, can answer that. But under the proposal that's been made in that the staff would review the applications, formerly we would get a list, I assume, of those that the staff found to be compliant. Is that something that we have to make a formal vote on? I would think so.
To have a list of the applications that are coming in?
Well, if the staff takes the first 20 applications and they check them all off, they all model law, they're fine, they should be issued a license. Do we have to ratify that?
No, those would be approved administratively at the department level if they meet all the criteria.
All right.
That's allowed by our statute.
Yes.
So if nothing else, then we would hopefully be given a list of those who were licensed. Not that we keep track individually. We do have our agenda and we know what was done. So we should, at least as a board, if nothing else, than to recognize that we had 110 applicants, for reciprocity. I mean, at some point there has to be some involvement.
Yep, and I believe we should be good with that. I don't know, JD, when they come in, if we could just add that to the minutes as to how many applications came in, and would the board like the names of the applicants as well, or just the number of applications?
Yes, I would
Okay.
like to see the names.
Okay. Yep. I don't foresee a reason why we couldn't do that. I will run that by internally, and I could get back to Tony on that one.
Yeah. So we'll come back with make sure we agree on the minutes, foreign degree, anything that had an NCAAS evaluation, certainly the first exams, a random selection of a few, anything that had a criminal past or a prior disciplinary action, which, as Rob points out, would probably be non-model law anyway, but those 6 categories for sure, and unless we thought of something else in the next few days, that I think would be a fair distribution.
Well, how about the ones that don't necessarily have an NCAAS evaluation and submit it on our state form? And those are kind of tricky to review and evaluate. Obviously, if they're NCAAS vetted and they are model law, then that makes it very easy to review them. But
well, Richard, I would say that we've come across that a couple of times, where NCAAS has evaluated it and said it was okay. And then we say, well, wait a minute, you're double counting the master's degree, and we're going to have one discussion on that this morning, and that doesn't, the NCAAS evaluation doesn't qualify it necessarily. That doesn't necessarily qualify it. We'd like to see that one. So including that in the list, I think, is good. Anytime there was an evaluation, let's see what the result was.
No. That's what I'm saying is that, once they're evaluated by NCAAS and they're actually model law, where they have a 4-year degree, they have the 2 tests taken, and they have the amount of experience they were looking for. Normally, those are not a problem.
Right. Okay. But I guess I'm redefining what NCAAS evaluation is. Yes, you're looking at it and saying it went through the clearinghouse, and Jane doesn't have to verify all the aspects of it because NCAAS did that. So that application comes through. NCAAS has said they're qualified by our model law. That's fine. Now they're a model law engineer. But if they had an evaluation of the education, we should see those.
Oh, no. I totally agree with that. But
Okay.
What I'm saying is that, there are applications that we review that do not go through NCAAS. There are the forms that we get, on the state website.
Okay, so that's another thing that I mentioned to John and Brian, is that not only do we want to update our statutes, we want to have it mandated that just one application. We're still getting, like today, we have an old application. The first 3 pages are instructions, Let's get to the meat of the application. So we should update the application being the only one we're going to accept, right?
Correct.
So that's another thing that, John, you can think about, is how do we get a standardized application? And on the website, you're going to fill out this application, you're going to go through NCAAS, and then you're going to submit it. One of the comments that was made is it takes so long, you have to do so many things. But on the other hand, if you know you want to work in Connecticut and you want to be licensed in Connecticut, you didn't think about it on Sunday morning and you want to do it on Monday, you've been planning. That's what engineering is. You have to plan. So plan ahead, do the application, send it in, and you'll get it, virtually the next day once you've submitted it to the state and the staff review.
Yeah.
Fair statement, John?
Yep. Right.
And
So-
I can attest to the fact that other states some of them do require that you do the NCS record.
Okay, so it's not unusual, and that's what we pay them for. All right, so I think that's a good suggestion, is that we, the board, the state, standardize an application, update the website, tell them what they have to do. You know what it is. Another thing that was discussed at the Northeast Zone, and it's discussed on every meeting, is, the requirement to get verification of employment. And so I was concentrating on it this week even more, because on the NCAA standard application, it's basically, you have any comments? None. It's like, yeah, I knew the guy. It's by rote. You just check off the box. Yeah, don't bother me. So every once in a while, we've come across a guy who says, look, I'm self-employed. I haven't had any contact but you have professionally, you've been submitting, even get the building inspector, whatever it takes. It should be attainable to find someone who can qualify your experience. So that was a comment. It takes a lot of time to get the what do you call it? References. So maybe that needs a little streamlining on the application. Do we really need 5 people that know you? You've been working at the same firm for 15 years, or you've had 7 jobs in the last 10 years, But that, John, is something I think we can think about. I didn't recall seeing in the statute that we need, or does the statute need to be revised on anything that refers to the application? We have to look at that closely, right?
I want to make a comment. I think having 5 review, whether they just check off the box or not, is important. Because
Okay.
if there is a problem, the hope is with 5, somebody's going to point it out.
Okay. It's
So I'd like-
it's been working for a long time, so let's just keep it.
Well, and also if you get the NCES record, you have to get the 5 reviews anyway, or the references anyway.
Right.
It's
So we
just
stay
part of the
consistent.
record.
Yeah.
And you have to have them updated every year, or every year that you want to use it, I guess. So,
Okay.
so it just seems like just keep that process in place.
Good. So we're really down to then just trying to standardize the application and letting us see these 6 categories at this point, and see how the system goes. John, what would be, the procedure for implementation of that? Does it start next month, or what has to be done on the department side?
So Janie is already comprising the applications as of now and going through them. So outside, and I don't know, Jane, if you want to add anything on this at the moment. I think that, Tony, if maybe if you had a moment just to review with Jane the process, and we could start implementing almost immediately. Just so that we're all on the same page as to how the documents are uploaded, making sure that there's a kind of like a checklist, for lack of better terminology, and we could start implementing almost immediately.
So since I met with you and Brian, and I should probably summarize, even though it shows in the minutes that we had a discussion today, and that we would like to see these categories come to the board, and give a brief reason why. That's all. And then it's the department's decision to do it, so we really don't have much of a choice. But because of that, we'd like to be able to stay involved, and these are the ones that we think are most critical. which give us the problem. I said to you and Brian at our meeting that, every month one of us comes up with something that says, guys, let's talk about this. And because of the way we're now, working remote, we do need a chance to share it with each other, right? Sometimes we refer back to John DeWolf because he knows the education curriculum. If it's a structural question, Richard and John get to help us. With less applications, then those critical ones can be distributed to all of us, so we can look at them together and have an intelligent, thorough conversation about those that may be problematic. So I think that's in my opinion, I think that is a good thing, that we all can see those that have been deemed potentially problematic. Okay, so if I will take that on just to summarize what we just discussed and say, and record what we think is important to us. Okay, so there's some advantages.
It makes a lot of sense not to be having all this stuff copied and sent out.
Right.
That it's so routine. So I really like the idea of cutting the paperwork, and I'm sure Jane especially does.
Right. Okay. So my initial reaction was we're getting cut out, but after a couple of discussions with Brian and John, you can see the merits of it on all sides, as long as we do have the opportunity to review the critical ones. Mm-hmm. Okay. So with that, I think that concludes that aspect of our discussion today. And because it involves everyone, including the surveyors, perhaps we could discuss briefly the legislative initiative. So one of the other things that we discussed at our meeting with Brian and John was that maybe you can help us out this time and put some pressure on the legislative department, to help us update our statute. And when Jane went digging, none of us would have recalled that it was back in 2012. Time flies, but I think it's a good opportunity, and the edits that we can make would be productive and not overwhelming or challenging to anyone else. So I went through it with John's lead initial commentary, and then I continued on. And if everybody did that, perhaps we should send them in to Jane for an edit, or I don't know if we can do it easily online at this moment. But I did have, and maybe we can record them and we can all look at them. Most of them came up on page 6, 7, and 8. John's recommendation on the edits to the first couple of paragraphs were certainly appropriate, relative to the date. And there's some other minor edits of grammar or punctuation. So would you want to go through real quick, if anybody has some outlines or questions? If not, I'll take the lead and put forth what I have. At least it'll be on the record for a moment. We can look at them.
I just have a question about the work that we did earlier this year regarding changing some of the language, specifically not requiring the U.S. survey foot, but allowing it to be, and then in specific datums, the wording in there that we talked about. Is that, could that all be changed now? Because last I had talked to Paul, I think it was Paul Grabowski, he said it wouldn't really be able to be done until next year. But since this is being opened up now,
right?
This is
the next year, so to speak. whatever legislative session's going on now, that's where we always rely on Al to keep us up to date on what the legislative process is. But I think those things would go in the regulations section, right? And this is a discussion of what changes in the statute. Am I correct on that, John Messner?
Yes. So the regulatory changes can be done within the department. Any statutory changes would have to go to legislation. So where we had left off at the meeting was after we wrap up this legislative session, if the board wanted to review and put something forward, what the commissioner had indicated was we'll put Tony in a meeting with myself, the commissioner, and our legislative liaison, CJ, to start looking at these and finding a direction.
Right. So not only myself, but anybody who wants to participate, obviously, because there's some fine points about this, and what's been edited out, we agree, is appropriate on our current version. But because of the time lapse, there are some other things that have to be addressed. So, let me just throw out what I had, as an idea of what kind of things I was concerned about, and we had discussed once before. I mentioned to Brian and John at our meeting that one of our problems at the time was the head of the General Law Committee who happened to have somebody in the family involved in fire protection layout. So we were careful to discuss the difference between preparation of a plan and a design. So a design is done by the engineer. I need so much water, for example, in the building. How it's distributed is done by the engineer, and then the fire sprinkler layout technician would prepare a plan to show how that water is distributed. So on page 3, the definition of an automatic sprinkler layout technician, we use the word design in the last sentence. I don't think we should have the word design in there. I think it should be he's permitted to prepare an automatic fire sprinkler system layout. And then on the next page, on page 4, at the top of the page, they define what a layout is. And we had a phrase in there, automatic fire sprinkler layout means preparing and designing. No, you don't design a shop drawing, you prepare a shop drawing, but you're not designing at that point. So I just suggested that means the preparation of shop drawings. It's just a minor thing, but it takes out the designing phrase. So those are things to consider, but those are two simple things. Maybe that makes sense. On the following page, page 2, which is the summary of the proposal and the justification, under 1, professional engineer, the definition of it, we have this issue now where we have to take out the word written exam because there is no written exam anymore for professional engineering. It's computer-based. So on the 1, 2, 3, 4, 5th line under paren 1, professional engineer, we have a written examination. I'm just changing it to passing of an examination.
I've thought about that some more, and we do need to preclude the possibility of an oral exam.
Right, yes, sir. And
maybe it could be written or computer-based, or maybe a national exam. I don't want.
Well, what it is, John, is it's the way it's phrased is successful passing of an examination prescribed by the board with the consent of the commissioner. So
that's good.
Right. So our board we're subscribed to NCWS, so it'll be the successful passing of an examination. So that was a minor grammatical change. But then over on page 3 of the justification section, paragraph paren 3, we're talking about the definition of land surveyor. And then we have 1, 2, 3, 4 lines from the bottom on page 3. We said there are ways to be qualified, right? One's graduation, and another one is 9 years or more of additional progressive experience in surveying work. It had been 6. We proposed to edit it out. Given the climate of surveying and the change in the technology and the way we work, I question whether or not 9 years is excessive. And perhaps it should remain 6 or 5, just for a discussion.
I personally don't have an issue with the 9 years.
Okay.
I don't have an issue with the 6 years either, for that matter, but you know, having a distinction between somebody has a degree and some experience, and then somebody who doesn't, to me, it makes sense that there's a little additional time putting together practical experience. So,
because it's a little excessive when you read the first part. We say you can be qualified under this circumstance: graduation from an approved curriculum of 2 years combined with 7 years of progressive experience. That's a lot. Or you could have 9 years or more of experience. My question is, your key man in your office, he's been doing it for 6 years. He's seen just about all he's ever going to see because he's not going to take on anything else, you see? So I think the 7 years is excessive when you have a 2-year curriculum behind you. And I think 9 years is just plain excessive when you're practicing on a daily basis in a profession that you want to succeed in. So I would question those at some point, but we could have more discussion on it. I just think that they're both excessive. 7 years after you have a 2-year curriculum, and then 9 years, suddenly qualifies you. So
well,
that was
if
it.
we have faith in the exam that we're subjecting an applicant to,
Yes.
in that case, if they can pass the exam, apparently they learned something somewhere.
Yes, sir. So you got 2 exams behind you, and that's the other part of it.
That's your argument for lessening the experience requirements. So
Yes, sir.
If we're all happy with 6, then we're happy with 6. I mean, let's not let's not make this something that it doesn't have to be.
No, we want some time. We want some time in the industry, and I think that if you made them both in this alternate path, we're showing alternate paths on page 3 under land surveyor.
Yeah.
So we should look at that because we were adding that section, you see. And I just think 7 years after a 2-year curriculum is excessive. And as you point out, it requires in the upper portion of that discussion that you take the exam and pass both of them, or all 3 of them.
So,
Okay.
So are we? Then the question becomes: what is the number that we're comfortable with?
Right. So we should talk about that amongst ourselves.
Well, I'm happy to participate in any discussion that pertains to the land surveying elements. Anyway, I'm sure most of you don't want my engineering opinions, but
No.
But I'll be happy to.
Yeah. You, me, Bob, Susan, we should, and Ryan, we should, just discuss that again. I've asked Susan, to spearhead that, to keep pressure on us about that. So then the next point that I had was bringing us over onto page 7 of the pamphlet of the justification, I guess. And we talked about, I just was going to question, I don't know who makes the decision. Maybe it's John, maybe it's a department, but at the bottom of page 7, which talks about appeals from the decision of the board, a new license or certificate to replace anything was $25. I don't even know if we replace certificates, and is that cost still valid? I don't know if anything has been updated on the list. It's not a question of whether or not it should be paid. It's a matter of whether or not this section accurately is current. That's all, on what do you charge. And that discussion comes up on the next page also. Upon application, the payment of a fee of $150, we're going to get a license. But I believe that fee right now is $285. So it was just a matter of reading this carefully and updating what's published. And maybe it has to have a sentence in there as may be modified from time to time. We don't have any control over that.
Why not just remove all fees from the statutes? I don't think the fees should be in the statutes. That should be something set up by the Department of Consumer Affairs. They don't need, that way
I believe this section, John, is under the justification, and then it was included by Steve Swain in this discussion. And I agree with you. Just say the payment of a fee established by the Department of Consumer Protection, right?
Yeah,
Well,
reference the fee.
That's the practical way to do it, because then you don't have to change the statute
Right.
every time the fee changes.
Yeah, payment of a fee established by the Department of Consumer Protection.
Citing
I
the
don't see-
specific
I don't
fee
even
is
see why you
like
need that
not
at
good
all.
planning. So it should
Sorry
just
about
say
that.
whatever the current fee is. You don't actually say what the specific fee is. You just say,
Correct. That's what I'm saying. This is under section 20-308 of the general statutes. Okay, so they were proposing to rewrite it, and all it says is upon application and the payment of a fee, the Department of Consumer Protection may authorize, the DCP may authorize the department to issue a license. So I think that needs to be, the law department, the legal division has to read it again in context and correct it, so we're just pointing out that needs to be corrected.
there are several current bills being reviewed in the legislature that would substantially lessen the licensing fee.
Right now they are?
Yeah. And so with, as is the case with all legislation, it's not done till it's done. But somebody rightly pointed out that Connecticut has the highest of the Northeast states, has the highest fee for a surveying license.
For everybody, that's a fact throughout the country.
The bill that seems to be rolling through would bring it down more in conformance with what all of our neighbors are doing. So,
Right. Okay. And that's why we kind of laugh a little bit when we discuss it. There's so many applicants for reciprocity, and we have the highest fee.
yeah.
All right. Shall we move on to the regular agenda?
So you're gonna redo this and have it circulated to the board?
What I was thinking about doing, John, you had made a couple of comments and I incorporated them in my quick edit. And then as you read through, there's a couple of sections where I write, we need to have the legal department review it. And this one discussion we just had was, no, we shouldn't be referencing any numbers or fees that can change on any year, right? So that would be something the legal people do. So, Jane, do you have this Word document?
I unfortunately only have the paper. I don't have the actual document.
And Steve Swain had done this from his department, whatever department may or may not. Would that be something we could check on within? Where was Steve working at the time, and do they have that kind of a file? Would certainly save everybody an awful lot of work.
Yes, I can see. He's been gone for quite some time. I don't know, but I can.
No, I know,
I'll see if I
but
can find out.
he was in some department. Whatever his work product was, they might have
He
it.
was in legal. He was one of our attorneys.
Yeah, no, I know. That's the name I couldn't think of the other day when we were asking. I couldn't remember Steve's last name. Okay, well, we'll get it over, and if you can find out if there's a Word document, then we can, or we just highlight this and say to the legal division, here's where we're coming from. These things need to be looked at by you, and we'd like to continue this. We have to put some pressure on a commissioner, since I'm so familiar with him now. I'll have to put the head on him. I don't know if John's still listening, but okay, let's do that. We'll look for the Word document. We'll share with each other anything that you've noticed in your review of it. I have mine in red right now. I will share those, and we'll see where we go. So we had one more item of correspondence, if I may. It was item A1, again, from the council. They're looking for engineers that are qualified in control systems to help on their professional activities and knowledge study in developing exams. So if anybody has any knowledge that they want to share and or references to people who could help, then that would be appreciated. The next thing I'd like to do is, typically as we do, and I don't see Janita on our list today, so I'll just pass over any enforcement. But we did have 2 items for surveyors on page 6, unless I missed one, which I can often do. But we had 2 applicants for Class 6 exam, credit part 1, Eric Franklin and Colin Palethorpe.
So Franklin, he's class 6. He's got less than 7 years. He's got like 6 years, 11 months, I think. But he doesn't actually have like any kind of 2-year degree. He's gone to 3 community colleges, but I didn't actually see any actual conference of a degree. And so I don't think he qualifies, because he really technically is a non-graduate and should have 9 years. And Susan came to the same conclusion I saw in her email. I'd like to know your thoughts, Bob. What did you come up with?
I agree with what Susan pointed out. I mean, I don't see that he qualifies for a lesser amount of time, with his current educational status. So,
yeah, I don't think he qualifies because he doesn't have an actual 2-year degree. He has 3 different colleges he went to and did well at, but never got the degree.
So the courses that he took in 3 different locations, was that a matter of accommodation, that you couldn't get everything you needed in different one, so you took them in different places? Does that make it an equivalent education?
Well, I don't know. I couldn't tell you yes or no, because I don't know what is required to get a 2-year degree.
Okay.
But it's in engineering, I can tell you that. He did engineering statics, introduction, adventure-based dynamics, differential equations, calculus, physics. So he's got a lot of engineering stuff, but again, none of it resulted in a degree that I can tell.
All right, so is there a motion?
Yeah, I'll make a motion that we deny Franklin for the time being because of lack of appropriate amount of experience.
I'll second that.
Any other discussion? All those in favor of the motion to deny Eric Franklin due to a lack of experience, say aye. Aye.
Aye.
Any opposed? Hearing none, that motion carries. Colin Palethorpe.
I recommend approval.
Second.
All those in favor of the motion, say aye. Aye.
Aye.
Any opposed? Hearing none, that motion carries. And then we had 3 applicants for Class 8 exam.
And I would move that we approve all 3.
I
Thank
second.
you, Robert. Any discussion? All those in favor say aye. Aye.
Aye.
Any opposed? Hearing none, that motion carries. And I believe that concludes our surveying items, which would bring us back to our regular agenda, page 2, which was reconsideration of Class 4 license. Rob Lewandowski reviewed Roy Karuba.
Yeah, so last month, we had Roy's application, and under the disciplinary section, he listed a couple things, but he didn't give an explanation, and it was vague and whatnot. So we tabled it and asked him to write a complete explanation of all the disciplinary actions that he had. He had a disciplinary action from 1994. He paid a $50 fine, settled it. 1995 had an issue, paid a $50 fine, settled it. 1999, this one didn't quite make sense to me, but he had an issue where a former employee was using his license to stamp plans, and yet he got fined $5,000. So I don't know why he got fined $5,000 when somebody else was actually in the wrong, but that's the explanation. I guess it's closed. And then in 2015, it looks like there was a little bit of a misunderstanding of stamping a set of plans for a slab design with regards to having the structural engineer designation. He had done a second. So there's some issues there. They seem to be old. They, quite frankly, don't seem to be monstrous. They seem to be settled. Other than that, his application is fine. He's not a model law, but it was just an older application. He's got a good degree, plenty of experience. He's been the owner of the firm since I think 93 or 95. So in my opinion, I would recommend approval, but I know it was distributed to everybody else. So if anybody else has an opinion, I'd be curious.
Nope. No, but I think it's fine. And just curiosity, were they all in the same state?
Yes, pretty. The first 3 were in Louisiana. All
Yeah.
4 were in the same state.
Yeah. Okay.
In his home state.
Yeah.
So I don't know. 2 of them were right out the gate, right when he started his firm.
Right. You wonder how long the theft of his seal goes. When I don't sit on mine, so it's in my drawer, but I don't sit on it. You know what I mean? So the guy took a seal and stamped it and went over to whatever, Georgia. It's a little interesting. Okay, they got it. All those. Is there a second to the motion to approve Roy Karuba for Class 4? Bob Doe, thank you. Any other discussion? All those in favor? Aye.
Aye.
Any opposed? Hearing none, that motion carries. Then we all looked at Mr. Hajar. I had an initial reaction, as I kind of mentioned it earlier on this morning, in that, are we doing engineering or are we checking slump tests or something? It just, he says it, change orders, traffic control plans, calming humps, engineering administration. We had said back in 2001 that what did we say? Your evaluation was completed in accordance with the criteria by NCWS and ABET, an accredited engineering program. They're evaluating the same, blah, blah, blah. So we agreed at the time in 2001 that the evaluation is deemed non-equivalent. So I don't know what else to say. In this case, on the, what did I read here? He took the exam. He took part A 6 times. 1, 2, 3, 4, 5, 6. And that was when you could do it every 6 months. So, my reaction is why do we need to change our initial decision? That was my reaction. And what he's doing is he's in his experience, he's been implementing the designs of others to his credit, but he's a resident engineer and not one in the design. And prior to that, he was a project manager. So my initial reaction was that it doesn't qualify, and there's nothing overriding to undo what we had previously decided. I welcome all comment.
Tony, when did we make the original decision?
We made the original decision according to the letter that we have here is that on March 12th, 2001.
Oh,
And then
sorry,
and then Rob reviewed it again on March 11th of this year, last month. And then we tabled it at that time for further review. Jane distributed it to all of us, and my feeling is there's nothing overwhelming in the change. And he's been a resident engineer in his last position, from 22 to 23. I don't know what he's doing right now. Prior to that, he was a chief inspector. Prior to that, he was a project manager. But basically,
Back on the record
traffic
here,
control and traffic calming as a resident engineer during construction. He's licensed in New York, current through July of 25.
Going back on my record from last month too, we had tabled it to have his degree evaluated as well, which this package had an evaluation that deemed it not equivalent. To
Right.
degree.
Correct. Well, my recommendation would be to maintain our prior decision. He's licensed in New York. And in this case, it doesn't seem to have had the undergraduate degree equivalency, and we had previously determined that it wasn't compliant.
Now, the only letter I see in what I received was from the National Council of Examiners, and it said it wasn't equivalent. I
Correct.
look at the courses and it looks perfectly equivalent to me. Maybe the basic sciences or something are not right, but certainly the list of engineering courses, he has a great breadth of engineering courses. So I don't see why it's not equivalent. And as I say, the only letter I see is the 2001 letter from the National Council of Examiners.
Yeah, that's all I had too, John.
Right.
I think I would not. I would
You don't
question
hesitate to approve it. Okay.
My fear is it's not equivalent because of humanities or something like that.
Well, it
Because
said
the engineering courses look great.
it said
Okay.
the apparent deficiencies are in the areas of mathematics and basic science basic sciences, and humanities, social sciences. So part of the deficiency is there, John, but part is in mathematics and basic sciences.
I'm not gonna worry about that. Personally,
Okay, would you like to make a motion to approve?
I'll move that he be approved.
Okay. Is there a second?
Second,
Thank you, Richard. John, we appreciate your input and your knowledge of the education curriculum, as usual. So all those in favor of the motion to approve Mr. Abdullah Hazer for reciprocity from New York, say aye. Aye.
aye.
Any opposed? Hearing none, that motion carried. Now, I reviewed the application for Yozheng Mao. He has 181 credits. And the question was whether or not there were any deficiencies. So I don't know. So we denied it back in December of 22. We denied it in January of 24 due to a lack of an engineering degree. He requested a reconsideration, and he provided an updated experience. So recently, he has been working for the city of Hartford in the traffic engineering division, and all of his expertise is concentrated in traffic. Georgia Department of Transportation was an extensive experience, 20 to 21. He's been the traffic service manager for Parsons, so he's all that. They're saying that the evaluation said he was missing 11 hours of engineering, but I really don't know what that was considered to be. So when you look at the transcript from the University of Kansas, there was a lot of English proficiency was done several times, but strength of materials, hydrology, not a lot more. Applied math, statistics. So it is master's program, soil mechanics, highway engineering, traffic engineering, urban mass transport. So he's concentrating in the field that he is now working. So I feel that the experience supports what he obtained the master's program in, which probably then justifies the deficiency, in my opinion, of what was in the undergraduate program, 11 hours. So I would say that my recommendation is to approve his reciprocity from Maryland. Excuse me, I don't actually have that. I don't have an updated verification of his licensing, or is it up to date, because it was June of 24. But pending verification that he is currently licensed in Maryland, I would recommend that his master's program and the strength of that program toward what he's working in would justify reciprocity. But I need to know that he's licensed.
I'll make the motion, subject to verification of current licensure, that he be approved for class 4.
Is there a second?
I'll second it.
Thank you, Robert. So all those in favor of the motion to approve Yusheng Mao for reciprocity pending verification of current license, in this case, Maryland, say aye.
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 Any opposed? Hearing none, that motion carries. And then the last one reviewed by Richard T. Sweetak was Tenzin Nyandak for reconsideration of Class 4 license.
I looked at it again, and I still come up with the fact that I believe he hasn't really practiced engineering for the required time period that we need under a licensed engineer. He basically he has a total of like 8 years of total experience. He has 2 years under an engineering firm, and then he has 4 years as an architect, and then he started his business 2 years and 4 months ago, where he's doing engineering and architecture in 2 different locations. And so what they're saying is that since he started his architectural and engineering firm, that he's been doing basically all engineering. And I don't know that I buy into the fact that he's doing only engineering in this new firm when it's an architectural engineering firm. So there's I know that when NCAAS evaluates something and they're only part-time in a certain profession and they're doing a lot of administrative work, they discount the fact that they don't take 100% of their time and saying, yeah, you've been doing engineering work when you're doing a lot of administrative work. So in that sense, I don't know that they say that, and I'll read what it says is regarding the references, please see the attached experience record form that now reflects 4.3 years of work under a licensed PE. One is current experience, and both PE experiences include dates and details explanation of Tenzin's engineering work. But you read it, but it doesn't really say what he does. The amended experience should address the board's concern. Kevin Cheng has been supervising Tenzin for almost 2.5 years as an experienced licensed PE. But if the guy owns the company, he should really be doing engineering, and I believe that Kevin Chen is doing the engineering for him, but he's not really doing the engineering. And it says our previous language in listing him as a reference meant to express that he is not an employee, but rather a senior advisor. So, again, I'm not sure what that means, but we've corrected it now and clarified that his role is synonymous as with direct supervision. So, but I think that what we're looking for is the person to be doing, active engineering, and actually doing, the calculations rather than having somebody else do it or sit down and in a meeting and says, yeah, what did you do? And, this is what we've done. And just by having discussions, by osmosis, that they get engineering experience. So in that sense, I think that, he really needs to do, he can't be running an architectural engineering firm in 2 different locations and be doing, engineering work full time. It just doesn't make any sense to me. I think that, he's lacking. I think he has a fine degree, he has, some experience, but he doesn't have, all the experience that I think that we're looking for, and, for reciprocity approval type of thing,
Where is he currently licensed?
He's currently licensed in New York, but and again, he doesn't have an NCAAS evaluation. Basically all he uses our online state form for his application, which doesn't necessarily vet and have all the references that NCAAS would have. The fact that you're doing engineering. Basically he just says, yeah, I'm doing engineering because I own the company. And I don't think that, I buy into that. And, and maybe we can have somebody else look at it. And I don't know if I'm the only one who got that,
Is it, would it be wrong to ask if his firms are registered
well,
corporations in Connecticut?
well, even his registration isn't, again, I'm pretty sure that he's registered in the state of New York, but everything that he has submitted is, a snippet of something that he found online. So it's not really verification from the state of, New York. Their engineering department hasn't confirmed it. Basically, he went online, he got a snippet of something, and he took a snapshot of it, and then he included it in his application. So it seems like, he's rushing, not that he won't eventually get, certified, and have the experience. But at this time, I don't believe that he has the kind of experience that we're really looking for in an engineer.
What's your question, John?
Why don't we have NCES evaluate? Tell them to run it through NCES and apply through that.
Well,
because if it turns out that they determine that he's a model law, next month we're not even going to see his application.
Well, that's fine. I don't really care.
Not that we shouldn't see it. This is a good example of why we should peruse them, perhaps.
Yeah, and like you said, and maybe I'm just being, too much of a designer, where I know what it takes to design a building, and I know that you just can't design a building because you talk to somebody and have a casual conversation with somebody. That ultimately the only way that you get experience is by doing it. And it gets down to the basics that John actually submitted for the fact that there's too much computer design being done and not enough real practical experience getting absorbed by people. Basically they run something through a computer, and the computer spits something out, and all of a sudden, you're everybody thinks that it's right and it's gospel truth. And the fact that, until you start doing it and designing it and then see how it looks in the field, you don't really know what you're doing.
The reason I asked whether or not his company is registered as an engineering entity in the state of Connecticut, that was one question, because
I don't know. No, he just says he has two offices, one in New York and one in Dramaza.
So he has, is it LLC? Is it Jimmy Inc.? What is it?
It just says Studio Nyack Architectural Engineering.
Okay, so if he's licensed, if that firm is licensed in New York and Connecticut as an engineering corporation, right? Is it better to have him licensed and responsible for the work product? That's all. It's just a question of if he's doing it, he's doing it, and we want him to be responsible for it. And he's going to continue doing it.
Well, he says he manages, the work of 4 professional engineers and 5 registered architects. So I mean, if he's managing it, he's not really designing.
I don't see that. Just if I can interrupt for a second, he's not. The firm is not registered in Connecticut with us.
So I think that's an extenuating circumstance, that he's offering to practice as a as a firm, but the firm's not registered. It's a problem.
Well, that's what I'm saying. In terms of, if he gets registered, then basically, he could do engineering in Connecticut without really having all the experience and all the, knowledge that he needs. And if he has other engineers who are registered under him, then that's fine. I
think the bigger problem is he's offering the services in Connecticut and he's not licensed. Now he wants to be licensed as an individual, but his firm is operating and not registered. Shouldn't he be registered as a firm?
I have no clue what
But-
is, you know, like you said, it's one of those online applications that, you know, you only get what they give you, you know, at least
So-
NCSS gives you some background, they give you some experience records, they give you, you know, their evaluations and whatnot, and, you know,
Well-
everything's, you know,
But Tony, are
in a
you,
proper process of doing, you know.
I wouldn't, I would either continue to table it and ask him for more information. And if he's offering to practice as an engineer and he's got a firm under him and he's not registered as a firm, I think that's a problem.
well, but we don't know that he's practicing or his firm is practicing in Connecticut, do we? I think that it seems to me he's trying to get licensed in Connecticut so that he can then license his firm in Connecticut so that he can then practice in Connecticut. I don't think there's any indication from what I've gathered listening to this that he's actually practicing in Connecticut at this point, or his firm is.
Yeah, well,
is that
you know,
true?
I think that's kind of irrelevant. I guess what we're really concentrating on is, does he have the kind of experience that we want to see? You know, he needs that 4 years of experience as an engineer, and he has, you know, 8 years of total experience as an architect and engineer, and he has, you know, 4 years of architectural in experience, but only 2 years of real you know, engineering experience, and then he has two years and 4 months running a, you know, an office. So,
Well,
you know, so
Richard, I think that I think what, you know, your comments are well taken, but in a practical sense, he's a licensed engineer in New York. He's supervising. He's got 4 engineers working for him and 4 architects. He can't possibly be the main number cruncher. Okay, so he has to be responsible. I think it behooves us to approve him to make him responsible. I think that, you know, the fact that he decided to go off on his own after working for 2 different firms. He did a lot of architecture. He has a qualifying degree, and now he's got his firm. I think that if we have to, we can't require him individually to create a firm and register it in Connecticut. He's licensed and assuming registered in New
I guess
York.
what I'm saying is that, you know, he made decisions to do certain things at a certain time. In reality, he could have waited until he had 4 years of experience as an engineer and then started his firm. But in reality, he only has 2 years of engineering. You know, I can't dictate what somebody else does. All I can dictate is that our regulation says he needs 4 years of practicing, you know, engineering experience. And, you know, I don't see that he has the 4 years of practicing engineering experience. He has 2 years, and then all of a sudden he's on some, you know, roundabout, you know, mission to create, you know, a firm and do all kinds of stuff, but he doesn't have the experience that we're looking for. And regardless of whether he's running a company or he's running 2 companies or 10 companies, you know, somewhere he needs that 4 years of experience doing engineering. And I just don't see that he has that 4 years. He has, you know, he's involved in it, but he doesn't.
We could argue that it's, you know, certainly progressive experience. You're not arguing that he has a good education, right?
No, he has a good education. No.
He has the education.
No.
But he's got progressive experience. He worked 2 years in a firm. He did a little bit more concentration on architecture. Maybe he designed all the foundations for the houses he worked on. You know, I don't know what his specialty is, and we don't discipline specific licensed people. So now he owns a firm and he's responsible for that. And he's got 4 engineers working for him. So is he setting the specifications? I don't know.
Well, the thing is, he could have 4 years, 4 engineers working for him, you know, but, you know, his engineers would take responsibility for design that they're doing for him.
I think in a way we sort of have to accept that he says he has the 4 years. He's certainly been involved. If he's doing architecture, it involves engineering, and so he's had that involvement. I am a little uncomfortable with questioning his specifics. He's had 8 years, right? Since he's got his degree of experience as an architect and engineer.
Right, his progressive experience, and he's evolved into the type of business firm that he is
Oh,
expert at. I would have a hard time on the basis of this, considering progressive experience and undergraduate degree and license in New York with a firm in New York. And I like what Ryan suggested, even though we don't know. He licensed himself. Now he can be the responsible charge in Connecticut. The other 4 engineers may all license in New York, and he doesn't want to pay the registration fee in Connecticut. Who knows? But I would say that on the basis of the undergraduate degree, the progressive experience, the firm with licensed engineers or engineers, I would say you have to accept them. That would be my vote.
yeah,
I'll
would
just
agree.
throw one more comment out there. And I do think that owning an engineering firm, even if you're not crunching the numbers, has a lot of value as experience in engineering. I obviously not the administrative stuff, but the managing engineers and the work of engineers below you. You have to know what to look for. And if you're a successful company, then it's evident that you're doing something right in that regard, I would think.
And the other thing is, so many of these applications that we review, you see the progression. The guy's been designing, and now he's in consultation. He's getting work. He's doing this. He's sending specifications, and he hasn't crunched numbers in 10 years. So I think you got to accept this one, based on what I hear, in my opinion.
And I agree with Tony. Sorry, Rich.
Yeah. All right.
So you want to make a motion to deny?
Well, if somebody makes a motion to accept it, then maybe I'll be the first negative vote we have in the whole wide world.
Okay.
Like I said, and maybe I'm being too obstinate in terms of I just, like you said.
I sit here, Richard, and quite honestly, I look at Ryan, I look at Bob Doan, I look at myself, and I say, and I know, and I'll include Bob Don in it too, but I know how we have to operate in our business because of the way we work. We crunch some numbers and we supervise, and maybe the crunching of the numbers is at the end of the day 25% of the oversight and conceptualizing and specifications. That's engineering. And then at the end of the day, you got to know that it's either right or wrong. And therefore, I move that we accept Tenzin Nyanjak for reciprocity. Is there a second?
I'll second.
So any further discussion?
What was the motion?
The motion was to approve Tenzin Nyanjak for reciprocity.
I'll second that. Yeah.
Is there any further discussion? All those in favor of the motion to approve Tenzin Nyanjak for reciprocity, say aye. Aye. Any opposed?
I oppose. See that?
Hey, that's healthy dialogue. We had some good discussion. All right.
And on that note, I'm going to leave, gentlemen. So
yes, thank you, Bob. Thank you very much.
You guys go on arguing in my absence.
Okay, thank you. That wasn't an argument. That was a discussion. All right.
Do the minutes. Oh, you already left.
The next the next item on our agenda is a list of candidates who passed the CBT exams. We have electrical, civil, mechanical, all the way through, one environmental. So that's just a list for our knowledge. The next group of applicants were Class 1 exam credit part 1. John DeWolf reviewed Berriman through Sullivan. These are the typical applications that under the new proposed procedure, we would definitely see.
Okay, I'm going to start with Hannah Kimball. Has a BS in business in New Hampshire, and then an MS in New Hampshire in engineering, which was a 2-year program with 30 hours. So basically, a bachelor's of business and a master's with 30 credits. She does not meet the need for a four-year engineering degree. So I move that Hannah Kimball not be approved because of lack of a four-year engineering degree.
Is there a second?
I'll second.
I'm sorry, I didn't see who was that. Bob Doan, or
Sure.
who's second?
Yeah, Bob did.
Okay, thank you. All those in favor of the motion to deny Hannah Kimball due to a lack of a qualifying undergraduate degree, say aye. Aye.
Aye.
Any opposed? Hearing none, that motion carries.
Okay, now Wayne Schneider has a BS in biology, an MS in environmental science, which I assume is not an engineering degree, and that was 37 credits, and then a MS in environmental engineering with 36 credits. So basically, once again, he does not have a four-year engineering degree, so I move that Wayne Schneider be denied for lack of a four-year engineering degree.
Is there a second?
I'll second.
Thank you, Al. All those in favor, is there any further discussion? If not, all those in favor of the motion to deny Wayne Schneider due to a lack of a four-year undergraduate degree, say aye. Aye.
Aye.
Any opposed? Hearing none, that motion carried.
Okay, I will point out that Michael Murphy has extensive experience all at EB, and he wrote a letter explaining that why he was not supervised by a PE, but he certainly was supervised by engineers that were not licensed. I think there's no problem with this thing. He's long-term experience. So I'm not going to, I do not think he should be required to have a PE sign on his thing, because of his experience at EB. So based on that, I'm going to move that from Berman to Sullivan, with the exception of Kimball and Schneider, be approved for credit part one, class one, credit part one.
So second?
Second.
Thank you, Bob. All those in favor of the motion, say aye. Aye.
Aye.
Any opposed? Hearing none, that motion carries. Then John DeWolf reviewed Ryan Bartos for class one exam. Take both parts.
He has a BS in environmental science. I looked it up. It's in natural science, sciences. So it is definitely a science degree. He has an MS in environmental engineering. And so once again, there's a candidate without a four-year engineering degree. So I vote that Ryan Bartos will be denied for lack of a four-year engineering degree.
I'll second.
Thank you, Al. Any further discussion? All those in favor of the motion to deny Ryan Bartos due to a lack of an qualifying undergraduate engineering degree, say aye. Aye.
Aye.
Any opposed? Hearing none, that motion carries. And John reviewed the last applicant, Muhammad Ahmed Khan, for class 2 exam, credit part 1.
So he has a BS from Pakistan, which was reviewed, and is missing 15 hours of math science, but he also has an MS from Kent State, and he has a total of 3 years of experience, so I think he's fine. So I move that Khan be approved.
Okay. Is there a second?
Second.
Richard? All those in favor of the motion to approve Mohammed Ahmed Khan for class 2 exam credit part 1, say aye. Aye.
Aye.
Aye.
Any opposed? Hearing on that, motion carries. I reviewed the next group of applicants for Class 4 reciprocity. So out of the 14, I should have written that down, only 3 were not model law. I wanted to read one section of James Bowman just for there it is. Let's see. James Bowman. He has criminal justice and a non-degree from the University of Buffalo. And therefore, I would deny this applicant due to a lack of a qualifying undergraduate degree. It just doesn't have that qualification. The transcript again from the 2 different schools provided in the second program, circuit analysis, electronic devices, higher level language, understanding music. So therefore, I would deny. He's registered in Connecticut, in New York through June of 27. So I don't know how that happens. Therefore, my motion in regarding James Bowman is to deny due to a lack of qualifying undergraduate engineering degree. So is there a second to that motion?
I'll second.
It's as far as discussion, it just, I don't understand, complete disregard for the basic aspect of the national model law for reciprocity. The bare minimum is the 4-year degree, and yet it's just completely ignored, with criminal justice, and it just doesn't make sense. So anyway, lacking any further discussion, all those in favor of the motion to deny James Bowman due to a lack of engineering degree, say aye. Aye.
Aye.
Aye.
Any opposed? Hearing none, that motion carries. So in the case of the other 13, only 2 were not model law. There was evaluation done on Bektas and Bilou, one with 153 credits, one with 167 credits. It's a good background undergraduate program. Therefore, my recommendation then would be to, my motion is to approve Abdul through Brown, accepting therefrom James Bowman for reciprocity. Is there a second to my motion?
Second.
Second.
Thank you, Bob. All those in favor of the motion to approve, say aye. Aye.
Aye.
Any opposed? Hearing none, that motion carries. It's always impressive also, there seem to be a lot of structural engineers, which I think is good. But also the number of model law engineers, which in this case, all but 2, 3, 4 have masters. So that's also a good trend. All right. So I took out Bowman, didn't I? I just had to make a couple of notations here. Okay, thank you for your patience. We move on to the next group of applicants for Class 4 reciprocity. Bob Doan reviewed Burr through Edwards on page 4 and Erickson through Harrison Billiot on page 5.
Okay, of the 18 applicants, only 2 were non-model law. One was deemed equivalent. And I would like to make a motion for the first 17. The last one I want to discuss further. But for this will be a motion to approve, but for Walter Dow, I need verification of a current license. And for Vincenzo Gerbino, we also need to verify a current license. And with that, I would like to make a motion to approve Burr through Halabi for a Class 4 license with those 2 conditions.
Okay, is there a second?
I'll second.
Thank you, Al. Any further discussion? If not, all those in favor of the motion to approve Burr through Edwards on page 4 and Erickson through Halabi on page 5 for reciprocity, say aye. Aye. Any opposed? Hearing none, that motion carries, which leaves us to Neil Harrison Billiot.
Okay, Neil Harrison Billiot is not a model law engineer. He has a Bachelor of Electrical Engineering Technology from the University of Maine, and he has 8 years, 8 months experience. He was denied an application with Indiana because it was not an ABET degree. However, under our policies, I think he qualifies because of the 8 years, 8 months experience. And looking at the transcript, he does have, circuit design and network analysis, and I think he has, not being an electrical engineer, I feel that he has enough of the engineering courses, and those were all engineering technology courses that he went through. So having said that, I will make a motion to approve him with the being a non-model law, but has the equivalent electrical engineering technology bachelor's.
All right. Is there a second? I'll second that. Want to have just, all those in favor of the motion to approve Neil Harrison Billiot for Class 4 reciprocity, say aye. Aye. Any opposed? Hearing none, that motion carries. I wanted to throw out something that was discussed in a graphic that was presented at this Northeast Zone. And one of the things was there's a constant recurring dialogue about whether or not there's a path to licensure for those people who choose to go to a technical college. They never have described or explained to me anyway satisfactorily why the opposition. But I hadn't heard this, but Indiana obviously is denied on that basis. One of the illustrations that they put up as a justification was on how applicants who are either in a 4-year degree or in a technology degree program fare on the FE. And they tried, well, they did. The graphics showed that first time takers, okay, under an ABET program, the passing was, let's say, something like 79%. And then the graph was way down on those in the ABET program. It was down somewhere around 49%, which I don't really understand why, but they, the psychometricians or whatever they're called, going by this, seem to show a pattern. I find it hard to understand, but I just wanted to put that out there.
So the students with the technology degrees did better than the ones with the conventional engineering four-year degree.
No, but just the reverse. The
The
first-time
technology,
takers under four-year program did 79% pass first time, 49% or thereabouts first-time technology degree for the fundamentals.
okay, I can add a little to that. At least when I was first teaching back when I started in 73, we were at the University of Connecticut accepting students from Hartford State Tech into our program and giving them credit for the first 2 years. And when looking at how they did, it was disastrous. They did not have the same kind of courses that our students did. And so they were getting credit for like statics and then moving on to mechanics and materials and failing it. And we met with a couple instructors, and this is obviously over 50 years ago, but we met with a couple instructors and they said we should not have been giving them credit for the earlier courses because they were not into the depth that our students had. So, that doesn't surprise me what you said.
Yeah. So
under the new, if we get this thing approved, then technology degrees would not be eligible for licensure.
So that's right. So we should make sure that that's on the list also, right?
I think so.
Yeah. So what we want to see tech degrees, because unless we legislate it out, which probably isn't a good idea, but the experience that has to take over. A couple of the outspoken engineers that are licensed and active in that group, they're outspoken in favor of technology degrees, but it's fortified by their experience, So you start to just focus on what you're good at, but you've not had that basic. And I think that graphic that they put up, really was telling. And I'm waiting to see if they were going to publish it. So I want to see if I can find it and pass it around. Remember that Jane? You remember? Maybe you were in the meeting at that time, right?
I think so.
Yeah, well, I had asked a question about, making certain I understood what they were trying to project right there. Okay, that's just it kind of supports what John just said, and all right, we'll see what happens next. Anyway, next group of applicants for reciprocity was Harvey through Meyer. Rob Lewandowski reviewed that group of applicants on page 5 of our regular agenda.
All right, I'm gonna pick one out. Jeffrey Lintag. His initial and only license is in Minnesota. He has a Bachelor of Science, PSE from Mapao Institute of Technology, foreign degree, and then a master's, De La Salle University. But the problem is Minnesota waived his fundamentals exam. So I believe with our regulations, that's a non-starter.
Right.
Correct?
He would have to go take that exam to get licensed in Connecticut.
So, I mean, if you look at things, he'd probably be okay, other than he got the FE waived to get this whole thing started. So is that a denial, or
Yes.
how do we characterize that?
Yes, he doesn't meet our requirements. It's a denial. And if he wants to go take the exam, then we can reconsider it.
Right.
So it's then, yeah, okay. So it's pretty simple denial, and just give him that note due to that, and he could be reconsidered if taken past the exam. So I recommend denial of Jeffrey Lintag due to a lack of FE exam,
Good. Second,
taken and passing.
I'll second.
thank you, John. All those in favor of the motion to deny Jeffrey Lintag for reciprocity due to the fact that he was granted a waiver for the FE. He's eligible to take the FE, CBT, it's available at his disposal. Any further discussion? All those in favor of the motion to deny, say aye. Aye. Any opposed? Hearing none, that motion carried.
All right, I'm gonna end up recommending the balance for approval, but I'll just highlight a couple of them. Donald Lazaro is not model law. It's one of the older applications, 28 years of experience, great degrees, good experience, so not a problem. James Lyons, also not model law, an older application, 29 plus years of experience, good degree, good experience, so he'll be okay. Samantha Meyer is not a model law due to a foreign degree. The degree was evaluated by NCES, deemed equivalent. Her experience was 6 years plus master's degree. And looking at her undergraduate degree and experience, her undergraduate degree is not accredited in engineering. So reviewing our standards, a non-accredited engineering undergraduate degree requires 6 years of experience instead of the 4, which she has. So
Where's the engineering degree from?
University College of Dublin.
Okay.
And NCS said it was equivalent, which usually they do find something wrong. So they did find it equivalent. So she ends up, after all those gyrations, checking all the boxes. So with that said, on my whole list, with the exception of Jeffrey Lintag, who we denied, I recommend approval for the balance.
Is there a second?
Second.
Thank you, Robert. So in this case, the UK agreement would be taken as check mark done. You have to give them a license, and they don't have to take the exam. And when I brought that up at this meeting, I guess I was in the mood for a little discussion this time. But when I brought it up, a couple of people stood up and like, it's going to happen. It's the right thing to do. You know, back and forth, no discussion. It's like they don't expect that they should come over here and take our minimum exam. So everybody has the opportunity to accept the agreement, or in our case, perhaps not. So I just wanted to point that out. Anyway, it's been moved and seconded to approve everyone from Harvey through Meyer on page 5, accepting therefrom Jeffrey Lintag. All those in favor say aye. Aye. Any opposed? Hearing none, that motion carries. And Richard reviewed the next group of applicants for Class 4 reciprocity, Mitchell through Reed and Russell through Stacy on page 5 and 6.
Okay, I want to start out with John Rafferty. In terms of, he has a bachelor's in environmental science and physics, which is a non-engineering degree. So I think that, you know, it's a non-starter. He has a master's in natural gas engineering and management from Oklahoma. But the fact that he does not have a qualified ABET engineering degree basically, you know, puts him out of, you know, the realm of being accepted. So
Right.
I'll make a motion that we deny him for lack of engineering degree.
I'll second it.
Who was that, Al?
Yep.
Denied due to lack of engineering degree.
4-year, a lack of a 4-year engineering
Yeah,
degree.
4-year accredited.
Yeah, the only thing that he did do is he did take 5 courses for general physics, differential linear equations, introduction to material science, thermodynamics, fluid dynamics, in as a supplement. But I don't think that that's enough to overcome
No,
the lack of a degree.
no. So it's been moved and seconded to deny John Rafferty due to the lack of a qualifying 4-year undergraduate engineering degree. All those in favor of the motion to deny, say aye.
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 Any opposed? Hearing none, that motion carries.
Okay, the next person that I sort of want to discuss is Carol Russell. She has a bachelor's, a master's, and a doctorate in electrical and computer engineering. But she got her initial degree or initial license from California, and California waived her fundamentals exam. But on her application, it says that she took a test in Colorado in February 2024, but I didn't see anything from Colorado that substantiated that. So if Jane could, I guess confirm that she did take the test in Colorado, then
for regular flammable.
Yeah, I can confirm that she took it on February 23rd, 2024.
okay, and she passed the exam.
Yes, she did.
Okay, so in
And
that
it was
sense,
the national exam?
Yep, it's on the, it's an NCES exam.
Okay.
okay. So in that sense, because if she did pass that exam, then she's fine. So
That is really neat to hear, because we have denied faculty members who won't take the first exam and don't think they have to. And here's one who just went and took it and passed it. And it shouldn't
Right.
be a big problem to go take it and pass it.
Yeah.
So
Right.
Okay, so that leaves you for the remainder.
okay, the remainder I'm gonna approve. And I had, some non-model laws, but they either were equivalent or they're just missing some, science, basic science degrees. So, I'll make a motion that we approve the remainder of the applications for, licenses.
Is there a second?
I'll second.
Second.
Oh.
All those in favor of the motion to approve Mitchell through Reed and Russell through Stacy, and a denial for John Rafferty, say aye. Aye.
Aye.
Any opposed? Hearing none, that motion carries. Then our last group of applicants in our regular agenda for reciprocity was Stam through Zabura, reviewed by John DeWolf on page 6 of our regular agenda.
I'm going to move them all, but I'll point out that James Stam was from McMaster and it met the NCES. Zhang has an MS in the US and a BS in China with no deficiencies. And Zybura has a BS in acoustical engineering and music from University of Hartford, which is a approved degree. And I looked at his experience and he's done an awful lot has a lot of experience in acoustical engineering. I'm impressed.
Wow.
So I move that Stam through Zybura be approved for class 4 licensure.
Is there a second? Think about. All those in favor of the motion to approve Stam through Zabura for reciprocity on page 6 of our regular agenda, say aye. Aye.
Aye.
Any opposed? But once Jack gets licensed, Jack Zabura, I'm going to make note of that because the next frontier in local zoning is sound.
Oh,
Yeah.
He's going to be in high demand.
Yeah, because of pickleball.
A degree from
Yeah,
Yale.
pickleball, exactly. It's like you can't believe it.
It's
So now we're
unbelievable.
doing padel courts. Okay.
They fly this one expert up from Florida all the time to tell us how many decibels they're gonna hear.
Bring them up in the winter.
Yeah,
My son and daughter-in-law are in Massachusetts, and the town, there's a park across from them, and the town approved 2 pickleball courts right across from them, and it's in the residential area. It took them, they finally got it disapproved because of the noise, and they had
Yeah.
an engineering expert in on acoustics to show you can't put it in a neighborhood near houses. It's just terrible, the sound. It's
Yeah.
continual.
It is, it's absolutely true. Even if you're playing it, it's bad. So we move on to page 7 of our regular agenda, which is approving Class 9 licenses for a variety of applicants. So is there a motion to approve those applicants? Amenta through Walden on page 7 of our regular agenda.
So
I'll make
moved.
a motion.
I got Mr. Doan and Mr. Swezak.
Give it to Mr. Bob.
All those in favor of the motion say aye.
Aye.
Any opposed? Hearing none, that motion carries. And Bob Doan reviewed 2 applicants for reinstatements, Molinsky and Collins, continuously licensed in another state.
I suspect that this will be the last time that I review reinstatements because this should be administratively reviewed also.
Yes, sir. I'll make note of that too. That's right.
Yeah. So I make a motion to approve both Smolinski and Collins for reinstatement.
Second,
I'll second. It was
thank you,
Bob.
Ryan. All those in favor of the motion to approve reinstatement for Smolinski and Collins, say aye.
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 Any opposed? Hearing none, that motion carries. And now we move on to our supplemental agenda. Yes, sir.
I don't think we ever approved the minutes.
No, I have it in this pile here, and I realized that I lost a couple of surveyors here, but we can do them one with some. Well, let's do it right now. We have a quorum, although we don't have the surveyors here, but I reviewed them. I made note of the fact that we had to look again at Hazer, and we did that. And we noticed a couple of denials. So is there a motion to accept or amend the minutes from March 11th?
I make a
I'll make a
motion
motion
to
to-
accept the minutes.
I'll second.
Thank you. All those in favor of the motion to approve the minutes from March 11th, say aye. Aye.
Aye.
Any opposed? Hearing none, that motion carries. We just put this in the right pile. All right, so that does bring us to our our supplemental agenda. And on page 1 of the supplemental agenda, John DeWolf reviewed 5 applicants for Class 1 exam credit Part 1, Bailey through Zinke.
I move approval of Bailey through Zinke, noting that Bailey didn't fill out the form properly, didn't put his BS degree on the actual form, but it is confirmed in the application. So I move Bailey through Zinke be approved for Class 1 credit Part 1.
I'll second.
Thank you, Al. All those in favor of the motion to approve Bailey through Zinke for Class 1 exam credit Part 1, say aye. Aye.
Aye.
Any opposed? Hearing none, that motion carries. I reviewed the next group of applicants for Class 4 reciprocity. Satyar Ayabozadu Sarasi. How'd I do, Jane? Okay? And then the next one is Blake, Bourne, Broadfoot, and Choate. I'll take Mr. Brett Bourne. Mr. Brett Bourne, I assume Mr. Brett Bourne, as a natural resources bachelor in natural resources, ECL and management. I'm not so sure I know what that is. I don't know if it's accredited. So do we have any input on that, Jane?
Where is it from?
It's a Bachelor in Natural Resource ECL, which I assumed was environmental. I don't know what it is, from Louisiana State. It was a 5-year undertaking. But I don't have any evidence that it's ABET accredited.
I would find it
Because
hard to believe that it's ABET accredited.
the only reason I questioned it was algebra and trade, chemistry, a lot of environmental oriented programs. So the question was whether or not, in fact, it was engineering. We have biology for scientists, organic chemistry, environmental chemistry of wetlands, English lit, materials of engineering, general physics. I didn't know by the title and reading it whether or not it was ABET accredited. And then there's a Master of Civil Engineering from Louisiana. All of his experience is related to coastal, which
It's a
makes
science
sense.
degree. I'm sure it's a science degree.
So I'll table it for the moment, but I need to feel comfortable because if I were looking at this transcript, I would not agree that it had the typical engineering ABET accredited curriculum.
Well, I looked up ABET for Louisiana State in Baton Rouge. That's not listed on there
No,
as being ABET accredited.
it is a science degree.
Yeah. You would agree, John, it doesn't sound equivalent, right?
Right.
Yeah. And again, I'll just read them quickly, just to go through. General chemistry, English competition, and composition, human geography in Europe. We had a college algebra, general chemistry, graphics, interpersonal communication, engineering computers, economic principles. You see, it just doesn't have the feel of static soils chemistry, so library research method, multidimensional, materials of engineering, general physical for technical statics, I guess, natural resource conservation. So it's a real science degree oriented to that. And then in the master's program, he went on and took fluid mechanics, coastal engineering, differential problem solving, and natural resources. So it's truly, the master's is truly oriented toward environmental, which is fine, but the undergraduate is lacking. So my recommendation was to deny due to a lack of a qualifying engineering degree, unless I can be advised otherwise. So that's my motion to deny for Brett Bourne.
Second.
Thank you, John. All those in favor of the motion to deny Brett Bourne due to a lack of qualifying undergraduate degree, say aye.
Aye.
Any opposed? Hearing none, that motion carries. I made note on this one when I reviewed it. I said, this is a case for the commissioner to understand how and why we need to see them. What was the catch? You gotta, when you see something other than BS engineering, natural resources should be it should be something that catches your eye. So we'll move on from there. The next group, the next applicants.
So
Excuse
just
me?
curious, was it listed as model law? It shouldn't have been. I just want to, I'd be
No,
curious.
it definitely was not.
Okay,
And the first thing I see is a Bachelor in Natural Resources, so that catches my eye. It wasn't FE. And again, I just, that's just the kind of this is the kind of application that needs to be noticed and then sent to the board for review. And again, to keep repeating it, I think that at the end of the day, there's fewer applications, and it shouldn't be difficult for the staff to say, 3 or 4 more applications. If there's any doubt, just send them to the board. So they should be willing to do that. So I would then recommend approval of Ayub Azad, Blake, Broadfoot, and Choate. Those were all model law, good experience, and all licensed in other jurisdictions. So my recommendation is to approve those applicants for reciprocity.
Second.
Thank you, Rob. Bob. All those in favor say aye. Aye.
Aye.
Any opposed? Hearing none, that motion carried. The next group of applicants was Collins through Hudgens, reviewed by Bob Doan on page 2 of our supplemental agenda.
I make a motion to approve Collins through Huggins with the condition that Christopher Diaz be verified for a current license.
Okay, is there a second?
I'll second.
Thanks, Al. All those in favor of the motion say aye.
Aye.
Any opposed? Hearing none, that motion carries. Rob Lewandowski reviewed the group of applicants, large, through Marone on page 2 of our supplemental agenda for Class 4 reciprocity.
All right, I'm going to end up recommending approval on them all. I'll highlight the outliers. Carl Lazone was not a model law. Bachelor of Science of Mechanical Engineering from UConn, 2013. He wrote on his application that he only has 3 years of experience. But he only had 3 years of experience in an engineering firm under an engineer. From there, he went on to work at the Bath Iron Works, continuing to do HVAC and plumbing design, just not under a professional engineer. So I'm assuming he's non-model law because he wrote in there only 3 years of experience. But when you look at it, he actually has 10 years of experience, in my opinion. So
Good.
I thought that was okay. The second one, Weijin Mei, non-model law, foreign degree, from China, was missing, not equivalent NCES, missing biology or chemistry. So 1 class short. On top of that, she has a Master of Science in Civil Engineering from Purdue University. So I thought that was okay.
Why, just because it was Purdue?
I gave a little nudge for that.
All right.
A little nudge. The balance of them were all model law, good degrees, good experience. So in the end, I recommend approval for all of them.
Second?
I'll second.
Thanks, John. All those in favor of the motion say aye. Aye.
Aye.
Any opposed? Hearing none, that motion carries. And our last group, no, not our last group, our penultimate group, Brian through Showman, reviewed by Richard Swezak on page 2 of our supplemental agenda.
I'll make a motion that we approve all 6 applications. I'll highlight Mr. Saratovsky. He has a degree from Belarusian University, but his equivalent, and he has almost 50 years of experience. So,
Wow.
Yes, he's an old timer, almost like me. So,
We can identify
with that
with
said, I'll make a motion. We approve all 6 of them.
Second?
I'll second.
Take it, Ryan. All those in favor of the motion to approve, say aye. Aye.
Aye.
Any opposed? Hearing none, that motion carries. And that leaves us to the last group on page 3 of our supplemental agenda, reviewed by Ryan Thompson. Schultz through Zhao.
I recommend approval for all of them. Of those 15, 9 are model law. 4 are only not model law because they are foreign degrees, but they're all equivalent, which is odd. I don't usually see that. And then 2 are not model law because they don't have NCES records, but if they did, they would be model law. So I recommend all approve.
Thank you, Brian. Is there a second? Thank you,
I'll
Bob.
second.
All those in favor of the motion to approve, say aye.
Aye.
Any opposed? Hearing none, that motion carries. Wow. That was a marathon. To Terry McCarthy, we outdid you.
Tony, I won't be here next month.
Okay,
Yeah, me too, because I'm gonna be in Colorado and it's our 50th wedding anniversary, so we're gonna be
No way.
traveling.
wow.
Oh,
You'll be in
congratulations.
no condition to think clearly.
I'm going
Yes,
to be in Sicily, and if I'm not there, I'm not going to have a 51st anniversary. So
There you go.
it's my 50th also.
There you
Good
go.
for you
Wow.
guys.
Congratulations.
Congratulations to both of you.
Oh, thank you.
All right. Then who's going to make the, well, we'll still have a quorum without you two guys. So you're both going to be gone. We better make sure everybody's there that day. Okay, May 11th. Well, congratulations on longevity.
Thanks.
All
It's
set.
finding the right
Motion
person, I
adjourned.
think.
What's that?
It's
Motion
finding the
to
right
adjourn.
person who puts up.
Thank
with
you,
it.
Al. There's no need for a second. All those in favor say aye. Aye.
Aye.
Thanks, guys. And you guys enjoy your celebrations and be healthy and safe travel. And we'll see you when you get back.
All right,
Richard, our wives are saints.
they are. So.
Have a great trip, guys.
Bye, guys.
Okay,
Thank you.
thanks. Okay, bye.
Take care.
Okay.